Stag. Stag. How busy? Greetings, 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 greetings. It is I, your king, King Clifford Jefferson. A Senator Godfrey, the fifth kind of band Jew, the son of Folk, who is the ruler of Jerusalem. I am the reincarnation of our king, King Edgar the Peaceful, which we know here at the Third Temple English Church of England is Jesus Christ, our Savior, who comes for his mystical body, i.e. Christ's body. All right, so this is going to be a lesson today based off part two. And part two of what was the last video I did. Just give me a second. Part two of help defending the Crown estates. Part two, calling on all criminal prosecutors. All right. Yes, all criminal prosecutors, all those who got their understanding based off the understanding of jurisprudence. I need you. I need you. I don't need you for presenting the evidence or the law. I just need you for your mitigating skill, your ability to be able to put people in a position to find them criminally at fault. You know what I'm saying? I can do this myself, but I just want to see to look at on their face when we, at the end of people, bring them up on charges for the very charges that they're accusing your king on, which was explained in my last lecture on part one, help defending Crown estates. Crown estates are called the Commonwealth rims, foreign lands, federal lands, or public public domain. All right, these are all the lands that were descended down to you as heirs of English descent, of Anglo-Saxon Berber descent. But you have no understanding of this birthright that was left from you based off what we call entail birthright. Entail birthright. The only birthright that one can possibly have is that of entail, because it's specifically left for heirs. If you don't not an heir, then this is not a benefit for you. You have no estate in any real estate of land in regards to some type of presumption of ownership. Because in all actuality, nobody really owns anything other than the crown. Because all land is allodial. That means it's superior of any overlord. Okay? It's owned by one entity. What that entity is, you have yet to understand. But we talk about it all day long here at the Third Temple English Church. So I must continue to go do it till you're made clear and you're up to speed, because you will not inherit what's promised to those who live by the laws of inheritance. All right. This is only promised for them. So this is not to be taken lightly of what's being revealed to you today, because I'm trying to show you your comprehension level as English heirs and successors. Right now, you're not even being born. You're not born yet. You're still in the cocoon. You're still in the evolutionary stage of your birth. All right. This is the resurrection. All right. You're in hell now. You're in the womb now. All right. You're going through the process of evolution, mutation. All right. You're mutating to who you are supposed to become. And that's an English heir success and successor. All right. We're going to prove it. So I want every one of you who build this lesson today, all right, who build this lesson today, as well as the lesson I did prior to this one, as well as all the other lessons I did today, I want you to see the comprehension and grounding that I give you based off the terminology that you use in regards to any type of claim and any type of inheritance that you so-called claim was promised to you by your ancestors. You must understand this, all right? You must understand it. So without further ado, let's get started. And as always, I have a narrative. I always keep a narrative. And the narrative is going to be our people, misnomer as Negro, Black, Colonial, Ethiopian, all these terms that had nothing to do with being an heir. Okay, this is very important. All right, because majority of people who are here who are not heirs are foreigners, migrants, immigrants. All right, you are granted a privilege to be here and to participate in the privileges and the liberties that are given by the laws here that were implied based off a quasi-government that was set up under what you call a republic, all right, under its former name, Commonwealth, all right, which was instituted by the House of Stewards, who were your reigning monarch at that particular time from the Parliament of Stuart, who were passed and legislated contrary to the laws of England, which I am trying to restore. All right, I am trying to restore your birthright, your inheritance, by bringing you back to the fruition of the understanding that you were predestined to come overstand with. If Frederick Douglass knew this back in the 1860s, then why come you don't know it? All right? He was the first recorder of deeds. The very door where the problem started was opened by him. All right? So he was the one who kept the record or instituted the record for the Doomsday Book. The Doomsday Book, or the bookland, or what we call folkland, in regards to the recordings of all feudal tenures of state that were recorded in what we call under the common recovery process through what we call fee simple, which is nothing more than an eminent domain power of the state that was gained through what we call escheat, when the land was considered to be absent of what we call heirs. And when that's the case, then it becomes what we call interstate, meaning there are no heirs. And when there are no heirs, then all feudal tenures that were given to the heirs are abolished, and the land becomes a lolio, which the king is next of kin under Anglo-Saxon law or Anglo-Saxon charter law, land patent law, deed law, whatever you want to call it. All right, we're gonna learn the difference today. So without further ado, let's get started with our narrative, because this is a problem that you all are having. All right, as a result of you not understanding real estate. What is a real estate? All right. What is a real estate? Because real estate deals with a bundle of rights, all right? A whole bundle of things that you must understand. And the people who are going to be the narrative today apparently don't understand what a bundle of rights are in regards to ownership of property, which 9/10 of the law is possession. Possession. Possession means ownership. If you possess something and you don't own it, then you don't have the right to possess it. One can possess nothing that he does not have. All right? Let's get to it. Promise I won't hold you long. I'm sorry my screen cut off on me last time. We had our last lecture, but it was a reason for that. It's because what I had to show everyone was some yeah, the last lesson that I taught to everyone, I had some case law that I was going to provide for you to qualify everything that I was going to use at our disposal. But as a result of people claiming to be English heirs successors, but not having established a body of politics to protect the English heirs successors, I have the right to keep everything internal so that we can preserve its integrity. All right. All right. So all those who trying to claim they're English or use their English rights and privileges, like it has been done from the time of our ignorance, you have no excuse. All right. You have no excuse. You will be held liable for everything that you're doing by way of you fleecing the people for their lack of ignorance in lieu of what they're understanding real estate, which you call trust law. All right. Yes, you call it trust law. You don't know a thing about trust law. All right. Or who gave you the ability to be entrusted with the estate on behalf of the beneficiary. You have no clue about that. All right. You cannot give what you don't possess. You can't sell what you don't own. All right. Recorder of deeds. Everybody know what that is. Frederick Douglass. Needs no introduction. If you read his biography, page 58, he clearly say that he was of Anglo-Saxon paternity. All right, meaning that he followed the birthright primogeniture agnatic succession setting law of primogeniture. All right, he understood that. He understood that. He was known. His friends were known as the kingsmaker. All right, not excluding himself or his family line, but notice that somewhere down the line of our descent that there was going to be a king. All right, that will be inherited the land back from who claimed to be the tenants at hand, i.e., the so-called landlords, which clearly the United States or all the states together as the United States under Article of Federation, as well as all those who got their power from calling themselves a so-called sovereign nation, clearly are not, because the so-called sovereigns under what we call prescription of sovereignty, someone claimed to be the sovereign without it being tested, were the House of Stewards. All right. And they got their authority from the House of Tutors under Henry VIII and Henry VII, who were nothing more than cadet branches for the Plantagenet crown, who I descend down from. All right, being that my surname is Godfrey. All right, let's get there. And Godfrey's father was Falkland. We know Falkland goes back to Anglo-Saxon charters, which deals with the inheritance going back to one single person in regards to the overseer of the estate, called that corporation sole. All right, that natural person. We already talked about this. We don't go through it loosely, but without further ado, let's get started. Recorder of deeds or deed registry is a government office, soon to be government office, tasked with maintaining public records and documents, especially recordings relating to real estate. All right, real estate ownership that provides persons other than the owner of a property with real rights over that property. So everybody who has an interest in real estate, an interest, a legal interest, not an equitable interest. There's a difference in the interest that you have in real estate, property concerning those bundle of rights. Because whatever you got it from as a grantee came from a grantor, and the grantor who gave it to you as a grantee in lieu of the conveyance can't prove that he had a good title in the first place. This is what we're going to discuss today. This is what we're going to prove today. This is what we're going to qualify today. And this is what you're going to overstand today. All right? Recorder of deeds, whoever that recorder of deeds, i.e. the clerk, which were tasked with the governmental task of maintaining the public records and document every recorded related to real estate ownership to provide persons other than the owner of property with real rights over that property. All right. This is why we have the Doomsday Book. The Doomsday Book, or the Bookland, or Folkland, was a recording of all the deeds that were given by way of letter patent, i.e. charter, from the original grantor, i.e. the owner, that apparently whoever the recorders are working for are not the original grantors. All right, they're acting as constituents to the conveyance of property that they only have a legal interest in and no equitable interest, which can only be dealt with what we call probate court. We know probate means to prove. They don't aim to prove who the owner is, because they know that's the only way they can own it is through acting as grantees. All right, high form of ownership in the United States is pretty simple. All right, let's get there. I could talk all day on this. Let's see. I have any moderators in today? Any moderators? All right, let's get there. I gotta wait on you to get in there. You're gonna miss out. All right, you're gonna miss out. I'm not backtracking. I'm not rewinding. You gotta catch up to the speed, the frequency, the vibration that we are here on at the Third Tip English Church. You gotta catch up. All right. Hold on. All right, let's get there.
There are a lot of great $600,000, $1 million, $2 million homes.
Your biggest decision is, do I want to go to the beach or the pool, and what am I going to grill for dinner? South Carolina, Hilton Head. What's going on there? People with families, everybody loves Hilton Head.
One of the best ways for an American family to create intergenerational wealth is to own some land. It's in high demand, and they don't make it anymore. I'm standing on the beach of the beautiful island of Hilton Head, South Carolina, where after the Civil War, Black people owned most of it. But over the decades, the land was lost. And to this day, we got Black folks that are still fighting to keep their little piece of the American dream. By 1910, African Americans owned around 16 million acres of land, much of it acquired through purchases and homesteading. But after years of violence, intimidation, and legal trickery, most of it was taken. Texas A&M law professor Thomas Mitchell has been tracking that loss for 2 decades.
Historically, if we're talking about African Americans, despite this incredible acquisition of land after the Civil War.
You hear that word? Acquisition of land after the Civil War. You gotta listen to these terms. Acquisition of land is a result of acquisition of sovereignty, all right? Which is a form of a prescription, all right? Use in property that you don't own, all right? A non-possessory use. That's what a deed does.
Most of that property was not considered prime real estate. For example, Hilton Head, South Carolina. Until 1950, Hilton Head was remote. There wasn't a bridge from the South Carolina mainland out to Hilton Head Island, and the island was owned by majority African Americans. Right. What does South Carolina do? They build a bridge. Real estate developers realize, oh, there's a great economic opportunity, and they have visions of what has become Hilton Head.
The indigo, rice, and long staple cotton of the past have given way to the golf, tennis, and swimming of today's leisure society.
They started buying out individual families. There's hardly any Black landowners left. And what's just happened as our society has advanced, areas that were once considered the backwaters no longer are the backwaters.
We're on a mission right now. Get this tangerine. The vulnerability of Black land isn't limited to the coastline. It's widespread throughout the United States, even in my hometown of Tallahassee. Sandra Thompson learned just how hard it can be to maintain possession of land that developers want to get their hands on. I remember growing up in Tallahassee. This was the stick. I went to school with people that lived out here. It'd be like, you live in the boonies, in the boondocks.
It's actually now zoned urban fringe.
Urban fringe.
Urban fringe.
People try to buy it.
All the time.
Sandra's family were sharecroppers on this land. Her grandparents bought it in 1946 using money their son made serving in the military. But their will didn't clearly identify a single person who would inherit and manage the property.
When my grandmother passed away, it was left equally to her descendants. So that essentially created heirs property.
Heirs.
Descendants, heirs. Heirs property. Descendant, heirs. And heirs property. Very, very, very important to understand that when they talk about heirs, they're talking about as a collective of a nation of people that's associated with a body of politics, and that body of politics protect the estate of the heirs by the laws. All right? You don't need to go and ask for something. The law is there to protect what's already in place. All right? We see that Frederick Douglass was giving land away to people who don't really own it. All right? So that includes you. If you do it under the process that was instituted and which Frederick Douglass had the undertaking of sitting in that office. All right. But he himself was of Anglo-Saxon fraternity. All right. Who actually gave out the charter to the deeds, i.e. the fiddle tenures estates. Because the actuality of the matter at point is that if you do have an interest in an estate, whether it's legal or equitable, it's still not yours because it belongs to the crown. Everybody want to do everything without the head. All right? You cannot do, what's a body without a head? It has no direction. And this is what's going on. Our body of people have no direction because we have no head to speak to voice our opinions about the conditions of the body, i.e. the body of politics. All right? Not you. The body of politics protect you as a natural person. All right? You must not forget these terms that I'm giving to you right now, because apparently the video in which you're viewing right now, they don't understand a word that we're talking about here at the Dirty Tip English Church. So listen.
Property. On the most basic level, what is it?
Heirs property is communal type property, where your ancestors would have purchased the land, and once they passed away, it transfers to the next generation and their descendants. It's fractional ownership, a property that could be owned by 200 people. Any one of those heirs could sell their percentage. That new owner can go to the court and say, well, we can't agree on how to manage this land.
And force the rest of the folk to sell it even if they don't want to?
Yes.
Okay. So they go to the court to deal with a property dispute among assumed people who are in possession of property. All right? But this is not dealing with heirship. The way they docket estates is not based off heir. It's based off what we call common recovery, ability to have an interest in property and be able to pass it, sell it, just like a corporation. They can do the same thing. All right, they can buy, sell, purchase, etc. All right, they can convey it. If they convey it either by a will, a last will and testament, all right, based off what we call life estates. All right, for the life of a estate, when the family dies out, when there is no heir, there is no kin, that means that it automatically goes back to the original grantor or the grantor who's in possession at that point in time. All right? But they're not doing it based off inheritance. They're doing it based off one's ability to have a right in property based off just the possession and little what we call right of use. All right? Falling under usury laws. Let's go there.
So it was essential for us to move it out of heirs property status. And in that process, costs from probate to title clearing close to about $10,000.
Wait, so you own the land, but then you had to pay $10,000 to own the land again?
Exactly.
Okay. So she said she owned the land, but then there was a clause on the title that she had to go back to probate court to pay $10,000 to claim ownership of the land again, when actually nothing that you filed on that record is proof of ownership. All right? Because you're subject to encumbrances imposed by the true grantor, the assumed grantor, which would be the state. All right? And it only got its right by way of the public use of what they call police powers through eminent domain. And that would not become a fact until the land is ceded because there were no heirs. This is an heir. So how is the land is ceding to somebody else other than an heir that she's talking about, because it's not based off heirship law, okay? Because land cannot be alienated. If you're not an alien, that means that you're a national and the land belongs to the nation. But what nation does she belong to, or what nation does she classify in regards to a right and interest in property? We're going to talk about that today.
Because of the cost. A lot of families don't clear title to their property. And so then it keeps them in a vulnerable economic risk position.
Economic risk position.
Disproportionately own heirs property that every lawyer who was knowledgeable about this ownership form would tell them, run away, do not ever own it under this structure. And so you're having a population sitting in this very vulnerable way, and oftentimes in a way that they don't understand how the law operates, sometimes until a lawsuit is filed.
Wow.
Man been in our family for at least 125 years. Started with my great-grandfather. Land is for me, a lot of memories, part of my roots. I was proud of the name Lewis. We worked in halves on.
You hear that? He said he was proud of the name Lewis. All right? That's his surname. But he's assuming to be black people. All right? Black were slaves, according to Dred Scott. So that whatever entail they had, estate became fee and simple. All right? Whatever estate they had in fee and simple in Scottish is called telelige. T-A-I-L-Z-E. Telelige estate, which is a form of estate that came about through the time of the Great Britain. All right? 1865, if I'm not mistaken. And then what they call Entail Abolishing Act. The Entail Abolishing Act. All right, we're going to talk about this, y'all. We only got two types of form of ownership in North America. Fee simple and entail. All those are subject to a lodio title. And lodio title means free and clear. That means that the only landlord is the grantor, the owner, the crown.
I guess say we lost.
The Lewis family owned 480 acres of land and a homestead in northern Louisiana. Because the land was heirs' property, several distant family members were able to sell their share of it to a local timber developer named James Tucker. Tucker forced the sale of the land that happened last year.
My great-great-grandfather raised 13 kids where that house sits. There are so many heirs tied into the Lewis properties. It'll make your head spin.
Louisiana Purchase, y'all.
Always paid on time. We were under the impression that could no one person from the family just up and sell any part of the property without anyone being notified.
Do you all know the relatives that sold their part?
I've only seen one once.
You in New York, wherever, going on with your life, you don't really know nothing about this little comfy spot right here. You don't know nothing about this here.
As part of the legal process, the forced sale of heirs' property has to be publicly announced. In the Lewis's situation, a local newspaper posted a notice in the weeks leading up to the auction.
This is a small town. Okay, this is not like the Washington Post or New York Journal or whatever, you know. There's no paper out here in the country that's being delivered to the doorstep. You know, ain't no ball riding no bicycle throwing no paper on the front porch down here. So walk in and just do a family like that. I don't understand that. My mama keep the insurance on this house. She keep a roof on this house. She keep their bills paid on this house. And my thing is, the house has been here for years. Because of technicality, you uprooted a family.
Uprooted a family.
Shortly after James Tuggle completed the purchase of the Lewis property last year, the sheriff evicted Michael. So this is where your trailer
was
foreclosure.
Those are the steps to the front end. I called the sheriff. Well, it's his property. He can do with what he wants.
The sheriff saying that Tuggle can do what he wants.
He can do what he wants. It's his property. I suggest you move the trailer. He says, well, that's all I can tell you. Is there anything I can help you with? I told him no.
Michael ended up with a little over $2,800 for his share of the property. He used it to relocate his trailer home to a half-acre lot nearby.
Still got to put in a water line. The water line's across the road. I could be angry to the point that I want to do something to somebody. I mean, you're talking about 125 years of family heritage.
You see how upset this brother is? I'm pretty sure all of you are at this stage right now, and they're waiting for you to act out. Okay? They're waiting for you to act out. Why do you think they brought the immigrants over here? To force you to act up. This is their intentions. Article 4, Section 3, Clause 2, dealing with what we call, Judge Scott said it, domestic, what's it called? Domestic, expatriate, not domestic, extraditing. All right, where they can expedite you for nothing. Post and profit laws. All right, trespassing laws. All right, bill of attainers. All right, these are the methods, bill of medicines. These are the things that they use to get you to act out as if you were doing something wrong because of these unconscionable contracts, which is done by what we call undue influence, which is a psychological control over your mind, and then puts you under duress to act out. All right, you know why they kept heirs in those long towers? Because long as the heir is alive, they can do whatever they want with the estate. If an heir dies, then it automatically goes back to the descendants. All right, that's why all our youth are in prison, because they don't want you to inherit the estate that were left for you from the original grantor, all right, called feudal tenure estate. That's why it was abolished, because they're saying that there are no heirs, so they can do what they want when under what they call commerce laws, commercial laws, all right? Because buying and selling is an act of commerce. It's an act of commerce, all right?
Michael invited us in to see the documents from the local district court that informed them their land was being targeted for sale.
This is a petition that came to us via sheriff department. This is the very first document that we received.
You're hereby cited to comply with the demand contained in the petition, which office is in the town of Homer and said parish state. You have
That's a lot of
15
words
days after
thrown
this.
at somebody that really can't understand some of the lingo, so to speak.
Do you hear this? Do y'all hear this? Hell, even the ones who are doing this to him don't understand the real language of land ownership. All right? They don't. What they're doing is fraudulent, but hell, you're ignorant about the fraudulent, so hell, they can get it off. Y'all better pay attention to what I'm telling you. Even your own people are doing it to you. Hell, they ain't even part of the government, and they're still trying to steal whatever estate you got left. All right? And they ain't even concerned about the immovable property. They talking about the intangible property, your assets, your money, your cars, your bank accounts. All this other stuff they're trying to take from you because they ain't got nothing themselves. They can never own something that they don't have. All right?
We get to the office to find out exactly what it is that they're trying to.
Attorney.
To make sense of these documents and get a better understanding of what happened to the Lewises, we visited the clerk of court, Brian Flynn.
Clerk of the court.
Anything involving the partition lawsuit is filed here in this office. I'm the custodian of all of these records that you see. So you want to take this out front?
Yeah, we take it.
All right, good deal.
When it comes to developers, what's the mechanism that they use to track down family members?
Okay, they'll come into this office, and then generally you know the piece of property that you're looking for. You know, whether that is because it's got some timber on it or something.
That's called meets and
And
bounds.
what you do is you can look at the tax assessor's office, and the tax assessor's office will give you just a visual plat, hand-drawn plat of how the property went from one person to the next person to the next person, and that's how they'll initially find out who owns the property.
That's called a property abstract, y'all. An abstract deed is called a property abstract, which is a search of the public record of who owns what or claims to own something in lieu of what we call instrument that's nothing more than an instrument that shows conveyance from one person to another. It doesn't prove ownership. All right? It does not prove ownership. So let me give you an example of what I'm talking about. All right? All right. Everybody see this? Is my screen sharing? Everybody see this, right? This is New Jersey real estate book. It centers on real estate. Everybody see that? This is a picture of the governmental building of New Jersey. It centers on real estate, 12th edition. All right? Twelfth edition. You see chain of title. All right? Chain of title. A chain of title shows a record of ownership of the property over a period of time. An abstract of title is a condensed history of all instruments affecting a particular parcel of land. Through the chain of title, the ownership of the property can be traced from its origin to its present owner. If this cannot be done, it is said there is a gap in the chain. Everybody hear that? There's a gap in the chain, meaning something missing. On this side is the grantor, on this side is the grantee, and in the middle it shows the conveyance. This is the record. This is the bookmark. This is the recording, all right, of every instrument filed from the grantor to the grantee, all right? And whatever the grantor gave to the grantee to show a good chain of title is based upon that instrument, right? Which is a deed, all right? Let's see. Evidence of a title. Through the chain of title, the ownership of the property can be traced from the origin of its present owner. If it cannot be done, it said there be a gap in the chain of title. Sometimes, however, it is necessary to establish ownership by a court action called a suit to acquire the title. That's what the lady said in regards to going down to the district court. She had to file $10,000 to acquire the title on property that she still don't own in lieu of somebody else claiming interest in the property based off an easement. All right? Based off an easement. How many know what an easement are? When dealing with owner of real estate, a purchaser or a lender, the grantor or the buyer, the seller or the buyer, the grantor or the grantee, when dealing with the owner of real estate, a purchaser or lender requires satisfactory proof that the seller is the owner and has a good title to the property. This documentary proof is called evidence of a title. This is what all you assume to have or presume to have in lieu of a claim to have a good title of the property that was conveyed to you based off it being conveyed by what we call an abstract title by an attorney and sanctioned by his opinion. All right? Every instrument that you have in lieu of a legal interest of property that was conveyed to you by an attorney, it was done by a practice of what we call common recovery. All right? And when common recovery is doing, they convey entail estates to fee simple, which is a violation of law. All right? The only way it can be done is by attorneys. And attorneys, when they sell property by way of a license, by way of what we call a broker, all right, he has a license to search the record and then give an abstract, property abstract of the chain of title, and then he'll validate it by his attorney's opinion. That's number one. Everybody see that? All right? This is everybody who has interest in the property, you need to know this. So the attorney's opinion in the abstract title that he assumed that is that the conveyance is good, he still wants you to get title insurance. Title insurance is not indefeasible. It's defeasible. Meaning they can't guarantee you a good title. So that's why you have to get title insurance to protect you, just in case a lien is put on it to acquire the title that you so-called say you have in the actual property based off the deed in which you have in your possession. All right? So abstract titles, by attorney's opinion, validated by a title insurance company, is called a deed. And the three forms of deed that they have here in North America: fee simple, fee indefeasible, and life estates, which runs out at the end of the life of the tenure. Okay? So based off these types of conveyances, which are three, is a deed is not proof of a title. It proves the grantor transferred the property, but does not prove the grantor had a good title in the first place. Is everybody seeing what I'm saying? Everybody see what I'm saying? Why is this so? Let's see why. Everybody see this? For attorney's opinion of title, which is not used as extensively as in the past, the seller's attorney usually orders the abstract continue to cover the current date. It is then submitted to the buyer's attorney, who must examine the entire abstract, follow his or her detailed examination. The attorney must evaluate all the facts and materials to prepare a written report for the purchaser on the condition of the ownership. This report is called an attorney's opinion title. Everybody understand that? Attorney's opinion title. Let's go back there. The next two are Torrens land title or Torrens certificate and certificate of title. Stats 3 and 4. A Torrens certificate is superior to the first two. Torrens certificate actually is indefeasible because it shows and proves that it goes back to the original grantor. And we know the original grantor, if you go to Torrens certificate on the Wikipedia, it will indefinitely be the crown. All right? It will be the crown. But for the sake of time, let's continue.
So what happened with the Lewises?
The Lewises are a family that is spread out across the United States.
Okay.
So James Terry Tuggle buys into that property. Now, he didn't just buy a sliver of that property. He ended up buying somewhere in the neighborhood of 20%.
An interest, not equitable interest.
That, he can force the entire thing to be sold,
And that's
which he did.
See how crooked they
over the
are?
course of a decade, Tuggle, a timber developer in town, bought the shares of more than 20 people connected to the Lewis property, most of them from out of state. He declined our request for an interview and didn't respond to our written questions.
So the sale happens at the sheriff's office, where it is publicly open for bid, and it's sold for $555,000.
And a bargain of a price, right?
Well, I mean, I don't know, $550,000.
For 500 acres?
Oh, I've seen 17 acres of land sold for $1,800, and believe me, that's disturbing.
The sale he's talking about was made in 2001 to a real estate investor named James Steele, who advertises his ability to force the sale of heirs' property. We caught up with him at a sheriff's auction nearby.
All right, suit number 41821 Tree Investments LLC versus Maurice Hunter et al.
In the courthouse, y'all.
Bid is $2,294.25. The floor is now open for bids. Do I hear a bid? Okay, $2,294.25. Sold.
Okay, that's how easy it is to do what they've been doing. All right? This is the proof, what they've been doing. Let me give you another example of it. So what you see this is right here. Foreclosure by the sheriff. We had a brother sitting in on the sheriff's sale. This is called adverse possession. All right, by hostile or adverse to another's property for prescriptive period. Prescriptive is prescription. Prescriptive is short for prescription. Prescription is a form of easement, which is a non-possessory use that was taken by way of the public encroaching on property that they call public property by way of the eminent domain power through fee simple. All right? This is a land taken for public use by any state. It says taken because it exceeded, because there was no heirs. Now, these people are claiming to be heirs, but the state are saying they're not heirs because of the way the conveyance is being done, which is by fee simple, not entail. Let's prove it. These are types of estates that have reverted and remainder interest. You see it right there. Remainder interest. All right. These are encumbrances. Fee determinable, fee simple, and life estate. Fee simple estates. Is the estate in fee simple is the highest type of interest in real estate recognized by law. A fee simple estate is one in which the holder is entitled to all the rights to the property. There is no time limit on fee simple estate. It is said to run forever. On the owner's death, the estate passes to the heir, his or her heirs. This term fee simple, and fee simple absolute are used interchangeably. All right? Everybody see that? Everybody see that? So they said the highest form of ownership in the state of New Jersey is fee simple. This is the book. That's the government building. Right? That's the dome. Domesday book. This is the book that gonna condemn them. Why? Because the highest form of ownership in land in New Jersey is fee simple. Based off this book, right there. That's a process called common recovery. We're going to prove it. Highest form of ownership, according to this book, under Title 46, colon 3 dash 46 colon 3 dash 10. 46 colon 3 dash 13 is when they changed entail estates to fee simple through the common recovery process, going back to the Plantagenet King, Edward I. Under Title 46, which is a title deal with possession, and possession means ownership. If you got something in your possession, you don't own it, and you own it, you have it in your possession unlawfully. You can't possess something that you do not own. I'm sorry, you don't. So if the book says the highest form of possession under New Jersey revised statute is fee simple, let's look at what the statute says. Whenever any conveyance, will, or instrument in writing shall hereafter be made whereby any grantee, devisee, or other person should become possessed in law or in equity of such an estate in real estate, as under the statute of the 13th of Edward I, called the statute of entail estate, would have been held an estate in fee tail of an type or character. Such conveyance, will, or instrument should vest an estate now in fee simple and such grantee, devisee, or other person. Did you hear that? So through common recovery, all the heirs who were descendants of Edward I, called the statutes of entail, now it has been transferred from entail estates to fee simple. All right? This is legislation showing you what the state of New Jersey did to your inheritance. It's right here. Alienation of freehold, status quo impetuous terram. I don't believe it ain't got no comments. This is crazy. Alienation of freehold. From and after March 18th, 1795, any freeholder may give, sell, or alien the real estate whereof he is, or at any time shall receive the fee simple, or at any part thereof at his pleasure. And such donee, purchaser, or alienee shall hold the same free of any tenure or service to the donor, seller, or alienator. All right? So this is how they alienating your property from changing it from entail property to fee simple. We just seen it right there. Both of these were permitted under the statute of entail and quid imperatores. It can only pass to an heir. But if there's no heir, then that means it intersteats. It steats, right? It goes, it's abandoned. Bona vacatia. All right? Come from behind it, Coco. (46:3-2). Certain tenures and holdings turn into free and common soakage. The tenures, honors, manors, lands, tenements, or hereditaments, or estates of inheritance at the common law, held either of the King of England, i.e. the crown, that could be anybody, which happens to be me, or of any other person, as is just qualified, or body of politics, or corporate at any time before July 4th, 1776, and declared by Section 3 of an act entitled An Act Concerning Tenure, passed February 18th, 1795, to be turned into free and common soakage from the time of their creation forever thereafter shall continue to be free and common soakage, discharge of all tenure charges and incidents enumerated in said Section 3. So that means that all the estates and land, which you call fiddle tenures or plots and lot numbers or parcel estates, are dissolved, abolished, discharged, okay, and remain under free and common soakage. Why would that be? Let's see. If the people in that video knew this, then they will be able to go to the probate court and prove that they had an estate that was subject to reversion and remandment. Gift, grants, and conveyances by state allodial. So this is the state statute under Title 46. All right? State statute under Title 46. And we're seeing here in New Jersey real estate book that the highest form of ownership in New Jersey is fee simple. Fee simple. Everybody see that? Freehold states are estates of indeterminate length. A person may own the estate for, matter of fact, let me go to the book. Back to the book. Okay, it says a person may hate a person. The first it says one song. Real estate are estates of indeterminable length. A person may own a estate for a lifetime or forever. Three freehold estates are recognized in New Jersey. That are fee simple, fee indeterminable, and life estates. Okay, they said forever. All right, so that means for the life of you. After that, then it must either go to back to the heir, the grantor, the heirs, the grantor, or it is sheets. If there ain't no heir and if there ain't no grantor. Because everybody's soon to be the grantor, but that has not been proven because the grantor is the crown. How we know it? New Jersey by statute. Grants, conveyances by state allotment. All gifts, grants, or conveyances made prior to the Declaration of Independence, which was July 4th, 1776, of any estate of inheritance by letter patent under the great seal of this state, or any other manner by this state, by the legislator thereof, or by the commissioners, i.e., board of commissioners, all right, that are subject to what we call municipal charters, no matter what they call special charters. These are read by the board of commissioners or agents of forfeited estates or by any other lawful competent authority, i.e. your attorney, under the state, shall be and remain elodial and not feudal tenure, parcel estates, freehold, fee simple, fee determinable, or life estate. Why? Because we just read that all those estates were dissolved, discharged, or abolished and remain under free and common soakers, as it was under the King of England or other person, body politics, or corporate through their body of politics, which is nothing more than a corporation soul. It shall forever be and continue in free and pure elodium forever. Discharge of all feudal tenures and the instances thereof and all other services whatsoever. All right? So this is my argument as your leader. What other leader, teacher, scholar, professor, magician can bring something and bring it to life, and it was already here sitting to be reformed? Who can do such a thing? None has done it except me. All under the body of politics that was established for the social order. All right? So there you had a little bit of statutory, parliamentary laws to qualify our position as English heir and descendants, being that the land is ceded because ain't no heirs, because everybody as Black people are losing their land because of fee simple common recovery practices that were done by the attorneys through their abstract titles, by their opinions qualified by a title insurance company, which in the nature is not indefeasible. All right? They're not indefeasible. All right, let's get there. Oh, this is not over by a loan shark. No. Body politics. Let's just review that again. Nobody want to get thumbs up, I get my own self a thumbs up. It's truly sad. You deny me in front of my father, I deny you in front of man. I hope y'all realize the choice y'all making. The body policy is a policy such as a city, whim, or state considered, from y'all understanding, metaphorically as a physical body. Okay? Physical body, meaning that a physical body is something that's tangible. All right? That means that the body of people who make up the state, i.e., the body of politics, are people that look just like you. All right? So that means it must take on a form of legal jurisprudence. All right? Not no spook abstract belief theory. It must have some jurisprudential significance, as it just said, dealing with our body of politics. As far as we can go back, according to our understanding, as Frederick Douglass understood it as an Anglo-Saxon fraternity, we must go back to the origin of corporations. All right? In Latin Europe, the body politic took on a jurisprudential significance by being identified with the legal theory of the corporation, gaining salience in political thought from the 13th century on. In English law, the image of the body politic developed into the theory of the king's two bodies and the crown and as corporation soul. So the 13th century will put you in the time of the Plantagenet crown. Okay? At the time of the Plantagenet crown, who was started by Godfrey V, Count of Anjou, son of Folk, ruler of Jerusalem, where the Anglo-Saxon letter patents were given by what we call bookland or folkland charters, where it goes back to the deeds that were filed within the county clerk, within the shire, which you call county shire, okay? And the original jurisprudence protecting the land that was under the authority of the corporation sold by the king who represented the crown by reference to by what we call the king's two body is me. All right? It's me. The body politics in English law jurisprudence deals with the crown as corporation soul, y'all. What is the crown? Or what is the purpose of the crown? Hell, but what's the crown? What is the purpose of the crown? Because you know what it is from a jurisprudence perspective. What is the concept? The concept of, let me make sure y'all see this. So you have no excuse for the choices that you make. The concept of the crown took form under the feudal system that was established back in 1066 when feudal were given from that allodial land under the authority of the crown, which was William the Conqueror who invaded England. Though not used this way in all countries that had the system, in England, all rights and privileges were ultimately bestowed by the ruler. Land, for instance, was granted by the crown to lords in exchange for feudal services, and they in turn granted land to a lesser lord. Okay, these are called tenants. One exception to this was common soakers, as we've seen in New Jersey by statute 46.3-1, 46.3-2, 46.3-6. All right, common soakers was the tenured, which was the fief that were paid by those who held tenure, such as those landlords and those lesser lords, under the authority of the letter patents granted by the crown, i.e. the king, i.e. the corporation sold. And the concept for which that was established was to make sure that the property stays within the church. Statute of mortmain, meaning it was a dead pledge. Okay? Owners of land held soakers held it in subject only to the crown. Which such land became ownerless, they are said to extinct, i.e. return to direct ownership of the crown, crown land. Bona vacatini is the royal prerogative by which unowned property, primarily unclaimed inheritance, becomes the property of the crown. So it's the highest form of land ownership in New Jersey as well as the United States, because the United States, nor New Jersey, under the corporation owns is allodial. So the only person who can own allodial is the crown. Because the crown steps in to take that which is left when it has no kin. See, Standard Oil Company versus, matter of fact, I'm not gonna give you that because then y'all be trying to use what I'm using for my ancestors' feet. I'm not giving that to you. All right. The crown is cheap. So let's go back to the chart. Because a lot of people have a hard time following words. Let's go to the chart. What part did you miss at as far as the interruption? Ain't nobody making no comments, so I'm assuming that it's good. Where did the disruption come in? Several times. If it came in several times, why are y'all just now informing me of the disruption? Is there anybody actually watching the lesson? Somebody inform me where the disruption or the interference came in. I'll wait for you. Countess Jones, where did the disruption that you mentioned? Where did we go? Where is the disruption in the video screen? What part did you miss out on? You're not telling me where. Is it still disrupting now? Oh, so you're talking about the video. All right, well, the video, you can see it and you can pull it up on your own time, but it's pretty much basically what I'm showing you that we suffer from today. People who own land back in the southern countries owned it by way of how it was established for estates to be filed for the record under what we call fee simple. All right, and we know the recorder of the deeds that was recorded fee simple was established by one of our forefathers, Frederick Douglass. He was recorder of deeds. All right, he was the recorder of deeds, and the purpose of the recorder of deeds was to file instruments of conveyance for other people other than the original owner. All right, that should be simple enough. That should be simple enough. So if the disturbance or the interruption came with the video, because the video has a lag, policy violation. Please. All the stuff they showing here, you talking about policy violation? Please. All right. If the truth is a policy violation, then y'all need to change the policy. All right. Y'all need to change the policy. Is this a violation of the policy, what I'm showing here? When a person dies, it is sheets. Okay? Everybody see that. From New Jersey real estate book on essentials or how to transfer, convey property that you don't own, it must first fall under its sheet. So it can be taken by those who use their acquisition powers through prescription, through eminent domain at the highest form called fee simple. All right? Fee simple. We know the crown was supposed to come here This was supposed to be the Crown, not New Jersey. Crown was supposed to be here. They removed the Crown in 1776 and put the colony, i.e., the province of New Jersey, now called the state of New Jersey. The state of New Jersey. Let's see. So the concept of the Crown was to return property that has become bona vacatia, that is ceded. That was the royal prerogative of the Crown, which is a corporation sold. All right? A corporation sold. Right there. The concept of Crown as a corporation sold was to take back property that is ceded. All right? When there's no heirs. Apparently, everybody are identified by the race game. So apparently, they ain't no heirs. So the only person that can say what belongs to heirs is the king, which is a natural person because black people are not natural people. All right? They don't have a nation. They don't have a body politic. They don't have a governmental structure, a public utility. You need that. All right? You need that in order to protect Crown land. All right? You need the Crown. You need the king. You need the corporation soul to protect Crown land. Because all land is cheats becomes back a part of Crown land. Let's prove it. Crown land. Thank you, Countess Jones, for the moderator. Get a little upset because of the ignorance of my people voluntarily, not involuntary, voluntary ignoring this truth. This is upsetting to me. So don't think Jesus coming back happy and smiling. If that's what y'all think, y'all in a world of trouble. Crown land, sometimes spelled Crown land, also known as royal domain, is a territory area belonging to the monarch who personifies the crown. Y'all know what personify is. So why y'all keep going through this spookism story? I don't know why. Because personify means the same as incarnate, incorporate, impersonate. All right? Yes, I'm impersonating the king. What's wrong with that? Somebody got to impersonate the king. All right? Somebody got to send that often. It's the equivalent of an entail estate and passes with the monarchy being inseparable from it today. In Commonwealth forms, Crown land is considered public land or federal land or public domain, which is part of the jewelry gallery of the Crown Corporation, so i.e. the king. It is separate from the private estate of the monarch. All right? Everybody see it right there. Crown land is personified by the crown and is an entail estate. What's the entail estate? Entail estate is called fee entail. Let's discuss that. Before we do that, let's go back to the body politics. Body politics from the abstract understanding. Body politics. Everybody see this. Body politics for us is associated with the corporation soul. You can associate with whatever you want to, a part of your social contract or social construct. All right. You can use it how you want to use it. All right. And if you use it like you want to use it, other than how the jurisprudence laid it down, then you're gonna fall into this category. The etymology or the abstract meaning, or the in lieu of the body of politics, which we know is the corporation soul, and the corporation soul personifies the crown and protects crown land. All right. So it says the term body politic derived from the Middle Latin corpus politicum, which itself derived from the corpus mission system originally designated the Catholic Church as the mystical body of Christ, but extends to politics from the 11th century on in the form of corpus republicae. All right, so it took on a political view in the 11th century. That would be the 12th. That would be 10th century. Okay, that would be the time of William the Conqueror. Popular terms exist as other European languages, such as the Italian, Polish, German, which means state body, an equivalent early modern French term, contemporary French court. Okay, so the word politics can either mean, from a jurisprudence perspective, going back to the corporation soul or the king's true body. When you want to take on an artificial perspective, then it falls into the 17th century. That comes into what we call a republic or a commonwealth. Yes, a republic or a commonwealth, which started in 1649 under the House of Stuart, which severed the crown prerogative. All right, severed the crown prerogative. So it says the body of politics is associated in your abstract as the mystical body of Christ. So let's take this mystical body of Christ from your perception and bring it concrete. All right? Bring it concrete. All right, so we know the mystical body of Christ deals with what we call the Last Supper. Jesus was in there arguing with theologians. He was in there arguing with the doctors of the law. All right? The doctors of the law, yeah. All those who go to bar associations and members of the bar, you better listen to me, because you're going to be in trouble. Y'all can watch it. Thank you for telling me that, Countess Jones. You can watch the video on your own, because I got a lot of stuff to cover. But if you watch the video after you watch this lecture, then it will put it right in its perspective, and you will see the path you need to take to come home. All right, all right. Because I'm only here concerned about my body of Christ. All right, that follows my body politics. That follows the law of my Father, who follows the law of the land, which is supreme law of the land, which is the law of limitations. All right, the law of limitations. Some things you just can't do. So in Christian theology, which was forced upon the Anglo-Saxon brothers in the 5th century by Pope Gregory I, through the Gregorian mission, which was still being implemented today, being that all our brothers and sisters who are in the church come from the Protestant movement, going back to the Protestants that were established by the House of Stuart. All right, it says here, the term body of Christ has two main but separate meanings. It may refer to Jesus Christ's words over the bread at the celebration of the Jewish feast of Passover, that this is my body. See the Last Supper. Or it may refer to all individuals who are in Christ. 4 Corinthians 12, chapter 12 through 14 verse. All right. So it's talking about aggregate, collective, and the soul. All right. They're talking about two stations, corporation soul and aggregate. The whole body of Christ and Jesus himself as the representation of what he represented, as a law governing the body. All right. Why is that so essential? Because we're talking about the body of Christ, the Passover, the Last Supper, and we know that Passover and the Last Supper, where his body of Christ took place, where it take place? In the upper room. We at the Third Temple English Church called the upper room Clifford's Inn. We call that Clifford's Inn. All right. We call that Clifford's Inn. Let's see what Clifford's Inn is. All right, let's see. We understand that our state was taken from attorneys who give abstract opinions based off the chain of title, abstract research of the chain of title provided by the county clerk for instruments that convey property absent of ownership, because they know the real ownership goes back to the original grantor as indefeasible title that can only be recalled by the original grantor. All right? We must understand that. And that's governed by that grantor's body of politics, i.e. his government. All right? And that will be the laws of parliament. And the legislation you see in the New Jersey by statute are actually the laws of the parliamentary laws that were still at the time of immemorial. Time immemorial, go back to Richard I, up until the present time that you see in the statute. And it shows you that crown land, i.e. entail land, i.e. fee entail, was changed into what we call fee simple through what we call the entail, abolishing of entail estate, going back to the statutes of entail, Edward the First. Okay, the statutes of entail, and when I'm mistaken, that will be 1295, somewhere around there. Don't quote me. All right. So, body of Christ, Passover, or the Last Supper is the abstract story to what you need to understand in a concrete way, so that you can understand that if you're actually a part of the body of Christ. Okay? That's what I'm raising you up to be a part of the body of Christ. We know to be Christ is to be Christ-like. Right? For ye are all God, for you are children of the Most High. Let's get there, y'all. Body of Christ. Passover. Last Supper. All right? Where do we hear this term from? All right? Clifford's Inn. This is why you can't trust attorneys, y'all. You can't trust them. They even got my first name, Clifford. My name is Clifford Jefferson. Clifford Godfrey. Clifford, descendant of Godfrey, the fifth Calaban Jew, son of folk, ruler of Jerusalem. All right? Everybody pull that up. Clifford's Inn. I got to make me another cup of coffee. All right? Everybody pull it up. Greetings to you, Archbishop Belmont, from the House of Belmont. Clifford's Inn. Clifford's Inn is the name of both a former Inns of Chancery. Chancery is called probate. In London, in a present mansion block on the same site. It is located between Federal Lane and Clifford's Inn Passage, which runs between Fleet Street and Transfer Lane in the city of London. The inn was founded in 1344 and refounded in June 15, 1668. It was dissolved in 1903 and most of its original structures were demolished. In 1934, save for a gateway which survived, it was both the first Inns of Chancery to be founded and the last to be demolished. The mansion block was built in the late 1930s, incorporating preserving the name. Originally, Clifford Inn was engaged in educating students in jurisprudence. Did y'all hear that? And jurisprudence. The Inns of Chancery evolved in tandem with the Inns of Court. During the 12th and 13th century law, was taught in the city of London primarily by the clergy. You hear that? So law was taught by the clergy. However, during the 13th century, two events happened which diminished this form of legal education. Firstly, as decreed by Henry III, son of John, son of Henry II, son of Godfrey V, Calabrian Jew, stated that no institute of legal education could exist in the city of London. And secondly, a papal bull prohibited clergy from teaching law in London. Consequently, the system of legal education dispersed, with lawyers instead settling on the outskirts of the city of London, but as close as possible to Westminster Hall, where the signing of the Magna Carta had led to the establishment of a permanent court. This is my ancestors, y'all. All right? So we're talking about the ends of court. Y'all see right there. Associated with the ends of chancery, but we know the ends of chancery is part of the chancery court, which is part of the king's prerogative. All right? Governance structure of the ends of chancery. All right? I don't want y'all reading that yet. Try to get back. All right? Y'all don't think I'm Jesus. Watch this. All right. Clifford N. we're talking about. We're talking about the governance and structure of the ends of chancery, i.e., the ends of court. Clifford N. was ruled by its council, which was led by a principal, i.e., the head officer. As well as the principals, the council consists of 12 barristers, i.e., the 12 disciples, all elected by the ends members and who enjoyed certain rights. They could hold chambers whenever they wanted and sat at a separate upper table to dine. Did y'all hear this? The principal was elected by the entire ends membership and was tasked with overseeing its day-to-day running and supervision of the ends servant. His privilege included the right to choose from any one of the 18 sets of chambers and a generous allowance for beer. Okay? Once again, Clifford N. was ruled by its council, which is led by a principal, as well as the principal. The council consisted of 12 barristers, all elected by the ends members who enjoyed certain rights. They could hold chambers whenever they wanted and sat at a separate upper table to dine. What would lawyers be sitting up in the upper room dining? Okay? Y'all need to ask yourself that. All right? These are barristers. These are lawyers. Y'all heard of the term breaking bread, right? Let's break bread together. Orange shopping orange. Only the best make it. The best of the best. All right? So the upper room where these barristers sit in as 12 barristers, i.e. attorneys, with a principal, i.e. a leader. But these barristers don't have a leader as designed by Clifford N. going back to the upper room, i.e. the Last Supper, i.e. the Passover, all right? Because the Passover about to happen this month, all right? This is where it all goes down. Why? Because I'm going to correct those in my father's house who now follow my father's law. And who would these people be? Those in the ends of court. Why? Let's see. We know crown land is entail land, and we know the king personifies crown land. All right? Y'all better listen to everything I show y'all today, and I'm gonna hold y'all liable. It's better you for not know this than know this and not follow it, because there is a record. Background to common recovery. A common recovery was a legal proceeding in England that enabled lawyers to convert an entail estate, a form of land ownership, also called fee-tail, into absolute ownership. Fee simple. This was accomplished through use of serious collusive legal procedures, some part in which were fictional and others unenforceable, and therefore null and void. Okay? That's what's going on today. It's been going on forever. There are null and void practices that have the face of law, but upon inspection, it is not. Okay? If you know law, you realize that the laws using to transfer and convey the properties that are in fee-tail are violations of the law because common recovery was abolished. You cannot sell an entail estate because it's left for heirs because it's crown land. Entail land, crown land, commonwealth, federal land, public domain all belongs to crown land, and it belongs to the heirs. When heirs is seized, as a result of interstate, the land is seized, and who takes it? The crown, because that is the whole purpose of the crown. All right? You must understand this. Common recovery changed entail estates into fee simple. Wrap that around y'all head. Okay? Please. And it was done by who? That enabled lawyers to convert an entail estate. Who are these lawyers? Bar association. A bar association is a professional association of lawyers, as generally organized in countries following the Anglo-American type of jurisprudence. Did y'all hear that? Did y'all hear that? It didn't say American Anglo, it said Anglo-American. So that means that Anglo-American would be Anglo-Saxon charter law or bookland, or what we call folkland, going back to the Doomsday Book or the Domes Book, which is a recording of all feudal tenures that were given out through the time of William the Conqueror and to the present. All right? The word bar derived from the Old English European custom of using a physical railing to separate the area that which court business is done from the viewing area from the general public. All right? From the general public. Let's get a little bit more on this. Bar association, members of the bar. Some bar associations are responsible for the regulation of legal professions in their jurisdiction. Others are professional organizations dedicated to serving their members. In many cases, they are both. In many Commonwealth jurisdictions, the bar association comprises lawyers who are qualified as barristers or advocates in particular versus solicitors. All right, so now we got a problem with this because a member of the bar association or a lawyer will defend your ass even if you're guilty or not. Okay? They don't care if you're guilty or not. Their job is to protect their client, whether it's for violating the law or for honoring the law. Okay? So that means if you're an attorney representing a criminal, knowing he violated the law, then you are one of these barristers who are not going contrary to what you were taught in the ends of court by that premio or that first person of order that selected the 12. Okay? Y'all messing with the wrong one. All right? Let's see where the origin comes from. Let's see. It says, the whole body of law is the legal profession comes ultimately from English custom in the early 16th century, a relevant device, dividing the hall of the Inns of Court. So Inns of the Court goes back to Clifford's Inn. All right? Yes, the Inns of Court goes back to Clifford's Inn, and Clifford's Inn is my first name. So everything you should be learning in that inn was based off what Clifford taught. My name is Clifford, and the jurisprudence going back to the legal jurisprudence that was taught in Clifford's Inn was that of Godfrey, i.e. Godfrey the Plantagenet, because he was the founder of the Plantagenet crown, the founder of the ruler, the father, the son of folk, ruler of Jerusalem, where folkland come from. Okay? All the same family, y'all. All the same family. Let's get there. The United States versus Lee. 1882 case. All right. These are receipts, y'all. I dare any one of y'all, those on their platform, to come talk to the king. Any one of them to come talk to the king. If you come talk to me, then there are responsibilities that you must uphold based off the social compact. You breached the social compact. All right, and decide to contract on your own. Okay? Let's get there. United States versus Lee. Everybody pull that up, please. Pull it up. United States versus Lee, 1882 case. Nobody takes it and try to use it for your own indulgence. Don't find yourself in trouble. I'm warning you. I'm warning you now. The only person who got this prerogative power is me. You do not have it. In all cases, let's start here. Little weight can be given to the decisions of English courts on this branch of subject for two reasons, right? First, in all cases where the title to property came into controversy between the crown and a subject, whether held in right of the person who was the king, back to 46.3-2, y'all. You see how I connect that? King or other person, body politic, corporate. See how that connects? King's to body? They got it right here in the case. In all cases where the title, not an interest in ownership, but an equitable interest in it, all right? Not 10%, 20%, because 9/10 of the law is possession. So you got to have more than 10%, 20% held. You got to have more than 50%, all right? And it must be an equitable interest, not based off the legal interest you got in the base of the actions or profits that you got off it. All right. It said in cases where the title of property came into controversy between the crown a subject, whether held in the right of a person who was the king or a representative of the nation, the petition of a right presented a judicial remedy at law. All right? A judicial remedy at law. A remedy which this court, on full examination in a case which required it, had to be practical and efficient. There has been, therefore, no necessity for suing the officer or servant of the king who held possession of such property when the issue could be made with the king himself as the defendant. Now, I'm a defendant. I'm a defendant, y'all. All right? Look at this. The person in this complaint is Clifford Jefferson. When you see my incorporation, it's Clifford Jefferson, but I'm a king. I'm a king. So I got the authority to do what I'm doing in regards to conveying property back to the original owner of the property, to a allodial. Because if it's a allodial, that means that nobody have an interest in the property in lieu of what we call the deeds filed for the county, which they sue me for in lieu of an unlawful claim of self-generated deed in lieu of ownership. I know a deed ain't proof of ownership because it's only an instrument that shows conveyance from one person to another, and that person who granted it to the other, I grantee, is not the original owner. Why? Because it cannot prove it has an indefeasible title. Why? Because one has the attorney's opinion on it, and the title search is abstract based off the property abstract, which is not indefeasible. Because if it's indefeasible, then you would not need title insurance. All right? You would not need title insurance. How many of y'all can drop it like that? Not even the attorney, the prosecutor, or the judge can drop it like that. Why? Because they're not the defendant in the matter. Check it out. Notwithstanding the progress which has been made since the days of the Stuart kings in stripping the crown of its power and prerogatives, it remains true today that the monarch is looked upon with too much reverence, all right, to be subject to the demands of the law of ordinary persons are, and the king's loving nation will be shocked at the spectacle of their queen being turned out of her pleasures garden by writ of ejectment against the garden. That garden happened to be Queen Anne. My mama's name is Betty Ann Jefferson, all right? That's my mama's name. My grandmother's name, Ruth Jefferson. Her sister's name is Ruth Jefferson, which is my great-grandmother. The crown remains the fountain of honor, and the surroundings which gives dignity and majesty to its possessor are cherished and enforced all the more strictly because of the loss of the real power in the government. Do y'all hear this? It is not to be expected, therefore, that the courts will permit their process to disturb the possessions of the crown by acting on its officers and agents. Did y'all hear that? Did y'all hear this? Apparently, you're not listening. So the crown separated the prerogatives, or divested the prerogatives in somebody else, and the Commonwealth under a republic, which you now have, absent of a monarch. Okay? You don't have 46-3-2. All right? You have a body of politics or corporate body politics acting off the eminent domain power or police powers through acquisition of sovereignty by prescription. All right, that's a mouthful for the public defender. All right, that's going to be a mouthful for them. Why? Because they're trying to convert fee simple property as if it's the proper form of conveyance when actually it should be entail. We're going to hear from the horse's mouth. We already seen it in the statute. Let's hear from the horse's mouth. Fee tail. Contrast to fee simple. Entail. In this common law, entail or entail, as distinct from telesai in Scottish law, is a form of fief, which is the trust of a fiefment given to a trustee for a beneficiary, subject to the use that is acquired by the trustee on behalf of maintaining the trust on behalf of the beneficiary, which is why they call it cessu que use. That's why it's called cessu que use. Established by the deed or settlement that restricts the sale of an inheritance of an estate in the real property, i.e. the immovable property, and prevents that property from being sold, divided by a will, last will and testament, or otherwise alienated by the tenants who are already in the position under common recovery through fee simple, fee indefeasible, or life estate. Instead, cause it to pass automatically by operation of law, i.e. statute of disposition, to an heir determined by the charter, i.e. the deed, i.e. the certificate of incorporation. Did you hear that, y'all? Did you hear that? Y'all got to be able to talk this, all right? The term entail, which is what we use, contrast to telesai, are medieval Latin fiefdom telelitum, which means to cut short. Entail deeds are in contrast to fee simple deeds, possessors of which have an unrestricted title to the property and are empowered to bequeath or dispose of it as they wish, although it may be subject to the allodial title of the monarch or the governing body with the power of eminent domain. Equivalent legal concepts exist or formerly exist in many other European countries and elsewhere. In Scottish law, telesai was codified in an Act of 1685, which is 1896, with the given short title as an entail act to abolish entail estates and now determine a fee simple to the eminent domain powers of the state by taking public property, which is private property, it's called public land, federal land, or private domain, which is called crown land because it's entail. All right? We must understand the difference. Why? Because if you understand the difference between telesai, fee simple, then fee entail is based off patriolimic or primogeniture. All right? Let's qualify. The fee entail crown land, i.e. the crown, i.e. corporation soul, allowed a patriarch to perpetuate his bloodline, family name, honors, and on memorials, and the persons of a series of powerful and wealthy male descendants, by keeping its state intact in the hands of one heir alone, and his ideally indefinite, preordained chain succession, his own wealth, power, and family honor will not be dissipated, divested among several male lines, as became the case, for example, all the other Frankish, Danish, American, and every other nationality that immigrated over here to this land that was governed under what we call the corporation soul. All right? We must understand the purpose of the entail estate and the purpose of why I'm here to protect the entail estate, because the entail estate is crown land, which is personified by me, and you can never separate it from it because it's subject to the statute of mortmain, dead pledge. It never leaves the hand of the monarch. It's just an interregnum right now, as under the presumption going back to the Commonwealth, because my ancestors were fighting over who would sit in that position as an heir, going all the way back to the War of the Roses that was established through Edward the First descendant. All right? Come on, y'all can't deny me this right. I won't let you do it if you wanted to deny me this right. Why? Let's see. Telesai, the Scottish example. As you comment myself. King got a wreck too. In Scottish law, you know that the estates were not entail because we know Scottish law abolished entail because they're the ones who instituted a commonwealth. All right? A commonwealth or what they call a republic. All right? You have a republic form of government. Article 4, Section 4. Okay? Article 4, Section 4. The feudal concept of the inheritance of immovable property according to an arbitrary course. You hear that? According to an arbitrary course that has been laid out, such as in documents known as a deed of telesai. It was codified by the Entail Act of 1685. Telesai is a similar to the common law concept of fee-tail, as the heir in telesai is entailed to the property heir in telesai is entailed to the property. And heir in telesai could not sell the property to inherited except to feud superior, that is, to the holder of dominium directum or of the feud. Okay, these are some of the so-called derivatives of that name. Telesai, telala. All right, totally different from entail, which is crown land, because you got different crowns: Scottish crown, English crown, and Irish crown. Whatever crown they got are not the same. They were just compiled together as an act under the English Civil War, or what we call the War of the Three Kingdoms: England's Parliament, Irish Parliament, and Scotland's Parliament. Okay, you have to know these facts. All right, so we know telesai and fee simple. Telesai is not based off an inheritance of fee simple because Charles II from James down to Charles II, all these minors were getting beheaded, excommunicated, and everything else. All right? So we need to understand that Dred Scott case said that slavery under Article 169, which deals with immigration and migration, was sanctioned by Article 1, Section 9, and regulated by Article 4, Section 3, Clause 2, through immigration and importation. Okay? We must understand that. Here we go. Now, ready? Everybody see this. New Jersey was the crown in 1776. 1776 Constitution, 1844 Constitution, 1947 Constitution are all adopted the common law of England, and they both recognize that the power of the legislature could not sever the King's Bench that was regulated through their immediate constitutions as sanctioned by the laws of King and Parliament. Okay? They could not separate the King's Bench. We know the King's Bench was the law of chancery, courts of common pleas, courts of exchequer, and all the other derivatives of the King's Bench or the King's Court that was regulated by the King and Parliament. Okay? We must understand that. So this is something from New Jersey courts, because these are the ones who suing me. All right? Show you how dumb these people are. Common law New Jersey courts. The meaning of the term common law was twofold. So let's go to the PDF meeting. All right? Let's get there. Coming to our closing. New Jersey's 1947 Constitution created a court system capable of responding to needs of New Jersey citizens and to the change in our society. For more than 7 decades, New Jersey Supreme Court has gained recognition nationally among states' high courts for its timely, prudent, and well-conceived innovations to the common law. There's only one common law, that's the common law of England, Smith versus Alabama, all right? The common law, like other judicial principles, arise out of court rulings, resolving controversies presented to courts by people in search of solutions. Individuals and others ordinarily, with the help of lawyers, select the issue to present to a court. In effect, the common law results from judicial decisions resolving those issues case by case. Being one of the original 13 colonies, New Jersey has been strongly influenced by the English law and the Anglo-Saxon tradition. The 3 branches of government enshrined in the United States Constitution and the New Jersey Constitution since 1844, as established in Billings versus Harris, are derived from English history. The king was the executive branch, parliament, the legislative branch, and the courts, the judicial branch. King in the bench, king's bench. It was in English judiciary that a formal civilized system for resolving disputes and addressing crime originated among English-speaking people. Aren't you all English-speaking people? You just lack your nationality to be represented by your body politics, by the king, which represented all 3 aspects of your government because it was a fusion of power. All right? It was the early courts of England that the common law took root and evolved into our current system of courts, judges, and juries, i.e., a jury of your own peers. The common law, we know it today, dates back to the 12th, 13th century and derived from the reign of King Henry II, who appointed judges to resolve disputes among his subjects. King Henry II was son of Godfrey, 5th Count of Bantu, son of Falk, ruler of Jerusalem, who I descend down from. Now, how the hell that's in the case law? Somebody please tell me that. I mean, not case law, but New Jersey's court. The meaning of the term common law was twofold. English court of common pleas addressed issues arising from quarrels among commoners, and the mission of such courts was to create a collective body of law based upon local customs. That is a unified system of law, common law, throughout all of England. So they're telling you that England is right here. Common law is rooted in the central role of judge and the continual restatement, gradual refinement of legal doctrine through court decisions. The common law is grounded in history and social interest, i.e. social construction, social compact, social contract, social compact. In deciding a case, the role of a judge is to interpret, apply early decisions or precedents. Did y'all hear that? Under the Anglo-Saxon tradition, litigation is by its nature adversarial. Litigation begins with a person filed a suit or a criminal complaint against another. Each side is the other adversary responsible for presenting evidence and arguing their position to a judge who renders impartial decisions based upon the merits of the facts presented in light of the law. The development of the centralized and hierarchical system of courts, which assured litigants of structural appeal process, was originally empowered by the English king and then by Parliament. See Chisholm versus Georgia, see United States versus O'Keefe. This appeal process was critical for the judiciary and the decision and gain the respect of the community at large. This was called a right of petition. Did y'all hear that? A right of petition. Evolution of the common law in New Jersey. New Jersey celebrates the thrive in its diversity. As a result, we have long been a place where competitive visions of American come into conflict. Nonetheless, a modern U.S. history has shown wherever America is going, New Jersey usually gets there first. Did y'all hear that? Did y'all hear that? So if you want to get there with me, you better recognize my power. When competing visions of a role of a state government in society, i.e. social compact, had come into conflict, our courts, as the 3rd branch of government, have been confronted with significant challenges. Sometimes in rendering decisions to difficult questions, various observers have expressed concern that our Supreme Court has been too assertive. Yet, as noted by retired New Jersey Supreme Court Justice Ray Stein, there are so many circumstances in which courts are required to act because the other branches of government have not. A great example would be the right to die case. Let's go a little further. right here, Chief Judge Vanderbilt. Not long after the adoption of the 1947 Constitution, Chief Judge Arthur T. Vanderbilt, after the revamp of the 1947 Constitution and his dissent in Fox versus Snow, expressed the approach of New Jersey Supreme Court regarding the need for the common law to continually evolve. The majority ruling on disputed estates and the intent of the dissent is long forgotten. Yet Vanderbilt's full-throated dissent has been followed by many other courts. The common law will be sapped of its lifeblood if Sterdices were to become a god instead of a god. We should not permit the dead hand of past to weigh so heavily upon the law that it perpetuates rules of law without reason. Finally, Vanderbilt quoted on one of his mentors, Harvard Law School Dean Roscoe Pound. Law must be stable, and yet it cannot stand still. Okay, there you have it. Common law of England goes back to the time of you, the heirs, Anglo-Saxon descendants from time immemorial. And we know time immemorial was established by Henry II's son, Richard I. All right, Richard the Lionheart. So you better have a heart of a lion to take your place in the affairs of men. All right, let's go here. In closing, a less proportion of idle property, Madison property rights, and the abolishing of fee tail. You hear that? They want to abolish our crown land, which is entail, fee tail versus fee simple, by way of the common recovery practice that they asked and practiced over here from the time that federal tenure over here, established by the Articles of Confederation, was given out, and this is how it was done. All right, you're about to see it right now. We're gonna warm my coffee up. Everybody better look at this. This is from where? Washington Lee Law Review by John F. Hart. About to wind it up, y'all. You know, the first colony in North America was Virginia, under the Commonwealth going back to 1649. A less proportion of idle proprietors, Madison property rights, and the abolition of retail. We know New Jersey Provincial Council was already here in 1776, and it was indefinite. All right. So let's see the overthrow, because if the crown was here, let me just show you, because I don't want y'all to think I'm lying. New Jersey Provincial Council. New Jersey Provincial Council was the upper house of New Jersey legislature, House of Lords, under the colonial rule until it was replaced by New Jersey Legislative Council under New Jersey's Constitution of 1776. So this is the overthrow. All right, the overthrow. We already read what they had on the New Jersey court site, said that the New Jersey origin of Anglo-Saxon was based upon the fusion of government, king of parliament and the king in its court. The history of the Provincial Council of New Jersey was established in 1702 upon the surrender by the property of East Jersey and West Jersey of the right of government to Queen Anne. Queen Anne was kicked out of her garden by who? The one she allowed to tend in her garden, i.e., what they call it, the planters, claimed to be descendant of the Plantagenet crown. Anne's government united two colonies as the province of New Jersey, a royal colony established under a new system of government. What type of government was this? The instructions from Queen Anne to Viscount Cornbury, the first world governor of New Jersey, outlined the fusion of power system which allowed for an overlap executive, legislative, judicial authority. It provided for a bicameral legislature consisting of a council and general assembly. Now you have a liberal democracy and a republic, which is liberal democracy is the vehicle for carrying out the social compact of the republic, which is nothing more than the Commonwealth that was brought over here from Great Britain when they took over the estate and transferred to what we call a Commonwealth by removing the monarch who protected entail estate because it could not protect it from the monarch who represents the crown. Who can drop it like that? Who can drop it like that but a monarch? You see here, 12 seats. That's those barristers in that upper room. All right? Authority of the crown. That would be the premier head. That would be the minor. And it's indefinite. All right? List of terms. What does indefinite mean? Indefinite means, let's see on the side. Lasted for an unknown, unstated length of time. Of a word, inflection, or phrase not determining the person, thing, time, etc. You hear that, y'all? You hear that? So the crown is perpetual, indefinite, all right? There can never be an interregnum. The reason why there wasn't an interregnum because there wasn't on the crown land. Crown land and the seat of the government for crown land was here in Perth Amboy, will be all now, okay? Perth Amboy, under the Jersey Provincial Council, all right? It was overthrown by the Jersey Legislative Council by William, when they locked up William Franklin under the authority of what they call William Patterson. All right, anybody know who Will Patterson is? Need to check him out. So we see New Jersey Provincial Council was the crown, all right? In 1776. Let's go back to the article now. A less proportion of idle proprietors, mass and property rights, and the abolition of entail. The Virginia statute enacted in 1776 abolished fee-tail estates and land forthrightly expressed a republic conception of property rights. This preamble asserts the perpetuation of property in certain families by means of gifts made to them in fee-taility, Scottish for entail, is contrary to good policy, tends to deceive fair traders who give a credit on the visible possession of an estate, and discourages the holder thereof from taking care and improving the same, and sometimes does injury to the morals of youth by rendering them independent of any disembodiment to their parents. You hear that, y'all? Let's go a little further. Render them independent and disobedient to their parents. The Assembly accordingly converted fee-tail estates, entail, into fee-simple estates, explicitly extinguishing the corresponding interest of the issue entailee, and those in reversion and remainder. You hear that? The statute thus transferred fee-tail estates already in existence as well as future fee-tail estates. It is well known that Thomas Jefferson, who bears the so-called surname Jefferson, but the citizenship of Thomas Jefferson, according to the Nationalist Act, had nothing to do with the geography, ethnicity, or nationality of those bearing that surname based off inheritance, genetic, what we call inheritance, a birthright, a fief, whatever it is. Thomas Jefferson had no right to convey, divest, or to even claim any property by way of succession, or i.e. deed succession, because that's the only way they could acquire property is by succession. And that's a part of acquisition. It is well known that Thomas Jefferson led the efforts to abolish, you hear that, fee-tail in Virginia, and that he later counted this legislation among his foremost achievements. Look at his book, his biography. But Jefferson abolishes fee-tail was essential to a well-ordered republic. You hear that? Commonwealth. But Jefferson abolishing fee-tail was essential to a well-ordered republic, which was borrowed from the Commonwealth. Abolition of fee-tail was a key part of a system of reform by which every fiber would be eradicated of ancient or future aristocracy and a foundation laid for a government truly republican, i.e. a commonwealth. What is not well known is that James Madison too endorsed Virginia's abolition of fee-tail. Madison, of course, is known for protecting property rights, not for extinguishing them. Madison charged the state laws were unjustly violating private rights under the Articles of Confederation, and he was a prominent in drafting the Constitution. Did you hear that? Madison composed lasting arguments in favor of constitutional protection for property rights in the Federalists, and he dragged and introduced in Congress the amendments that became the Bill of Rights, proposing the taking clause in himself. Taking clause is the what they call, if I'm not mistaken, Article 4, Section 3, Clause 3. Article 4, Section 3. What's this called? The property clause. All right. Property clause is the taking clause. All right. So it says that the taking clause, Madison introduces the Bill of Rights and also proposing the taking clause himself. Therefore, Madison supported for abolition of fee-tail, which extinguished property rights deriving from fee-tail tenure merits investigation. So why would you, as an heir, abolish something that was put in place to protect the inheritance from time immemorial if you were that descendant that you claim to be? Hear that? Straight lies. Virginia abolition of fee-tail shows, I will argue, that we need to revive substantially our historical understanding of what property rights Madison thought deserved constitutional protection. The prevailing view among modern scholars is that Madison and other framers of the Constitution and Bill of Rights favored withdrawing property rights generally from the realm of politics to that fundamental law to insulate private property rights legislative interference. But the abolition of detail shows that even Madison was not nearly so libertarian as has been thought. Virginia Act of 1776, by extinguishing the property rights of heirs, reversion and remandering growing out of fee-tail tenure, took wealth and transferred to tenants entail, i.e. fee simple. Madison's support for abolishing fee-tail shows that his political philosophy of protecting private property in his sense of fundamental justice allowed far greater scope for legislative intervention than has been recognized. Let's get there. Right here. The fee-tail estate in Colonial Virginia. To evaluate the practical impact of the Act of 1776, an act to abolish fee-tail is necessary to assert the substance of Virginia's law of fee-tail before 1776. Did y'all hear that? Analysis must begin with looking at the English background. Fee-tail or entail was a grant of land to aid and to the heirs of his body of politics. It was already in use before 1285 when Parliament enacted the statute de Donis Conditionalities by Edward I, which is the Act of Entail. All right, the Donis Conditionalities, responding to petition from landowners who wanted to bestow on a child into the heirs of his or her body an inheritable estate in the land that could not be alienated in fee simple. So if they're talking about entail estate and entail versus or contrast to fee simple estates by eminent domain by the colonists, that means that our ancestors at the time of the colonists who got here in the 18th, 19th, as well as the 20th and 21st century were the ones who owned these lands entail because you got the English name. That means that your citizenship becomes a diversity issue because of the diversity of citizenship, all right? Which is based upon proof, evidence, all right? Evidence, here's your evidence. The first tenant entail would hold the rough equivalent of a life estate, which is a feudal tenure estate. If he or she died with no heirs and no remainder limited to follow, the land will revert by operation of law to the grantor or the grantor's heirs in fee simple. Hold up, wait a minute, that's a lie. That's a lie. So if you read this and don't understand what you're reading, then you fall right back into the okie doke because fee simple is the eminent domain power that the state have by way of land that is ceded as a result of heirs, and the only way that happens is a result of the process of common recovery. Did y'all hear that? Let's read it. For many years after 1285, I got this couple parts of this. Well, that's up. All right. For many years after 1285, it was uncertain how long fee-tail restraints on alienation were effective. Some do the restraints on alienation was enforceable only against the first tenant entail. Others thought the restraint could for 3 generations or until the entry of the third heir entail. The view that retail was potentially infinite in duration eventually prevailed over time. You hear that? But this development was in turn largely eclipsed by another, i.e., what we call full eclipse, April 8th. What we call that? The dragon year. All right, the year of the dragon. All right, we understand that that deals with what we call the Passover. We know the Passover deals with the body of politics or the God, Christ's body. All right, in regards to their resurrection of the overstanding of who they are as heirs. These proceedings properly orchestrated left the heir entail the reversion remandering men with worthless causes of action against a nominal defendant, sometimes the court crier, i.e. the petitioner, while converting the tenant's intent into fee simple, collusive common recovery has been so familiar over the years as to be considered a matter of right prior to the English settlement in Virginia. You hear that? So prior to the settlement of Virginia and English common under English common law, common recovery was not the practice. All right? It was not the practice. Let's go to another one. An act declaring tenants of lands for slaves entitled to hold the same in fee simple. And the act, this is from the General Assembly. Everybody see that? An act declaring tenants of lands or slaves entitled. They're using the Scottish form. You hear that? The Scottish king severed the crown. So when you're talking about slaves entitled, you're talking about Dred Scott and every other African American who came up under the body of politics that came through the English Civil War, known as what we call a republic form of government, which was the interregnum because the monarch, the jury speaking, was missing. All right? We know Dred Scott said that slavery under Article 1, Section 9 was integrated and incorporated in the colonies under the Articles of Confederation, where Thomas Jefferson and James Madison were actually one of the proprietors of that. Okay? An act declaring tenants of lands of slaves entitled Scottish slaves to hold the same in fee simple passed October 14, 1776 session of the General Assembly legislature abolishing the feudal English property rule of entail, which protected land from answering any debt accumulated by spendthrift offspring. Thomas Jefferson complained in his autobiography that the result of this in primogeniture of automatically passing inheritance to the elder son was the accumulation of perpetuation of wealth in select families. As part of his attempt at a comprehensive legal reform, he authored this bill. You hear that? He authored this bill. All right. So in closing, all right, in closing, book land was a type of land tenure under Anglo-Saxon law and referred to the land that was vested by a charter. Land held without a charter was known as folk land. All right? Land held without a charter is called folk land. All right? We know folk goes back to folk the fifth rule of Jerusalem. So all the land belongs to folk because all the descendants of folk of Jerusalem were in the state of hell. All right? They were in the state of hell by way of what we call the Star Chamber. All right? Historical background. All right? By ancient law and custom, folk land was the only means of holding land in Anglo-Saxon England, referred to land held by a single person, i.e., what they call it, entail land, as a representative of kinship group. Land could be permanently transferred outside of the kinship group or alienated, but only at the agreement of the king and parliament. Failing that, the land could be transferred only within the king's group, for example, through inheritance. Okay? We go to Anglo-Saxon Charter. Anglo-Saxon law, English, doom, decree, judgment. It's a body of written rules. You hear that? Later decree, judgment. English, et, later, lagu, law, doom, decree, judgment. So Anglo-Saxon law is the later decree or judgment based off the law governing the charges given out by the queen. And we know that's based upon conquest. And we know conquest is prescription because somebody claimed to be the sovereign and they're not. All right. And the only person that can be doing that is bastards. And the body of written rules and customs that were in place during the Anglo-Saxon period in England before Norman conquest, this body of law, along with early medieval Scandinavian law and Germanic law, descended from a family of ancient Germanic customs and legal thought. However, Anglo-Saxon law codes are distinct from other Germanic legal statements known as leges barbarorum, in part because they were written in Old English instead of Latin. The laws of Anglo-Saxon were the second medieval Western Europe after those of the Irish to be expressed in the language of Latin. All right. Oh yeah. All right. So we know about Anglo-Saxon charters, Brookland, or Doomsday Book. So let's close out on this article from New Jersey courts again. It says New Jersey is the crown. Everybody better focus in on that. That's being shown. But this is where your remedy comes from. All right? This is where your remedy comes from. So for all those who are viewing this lecture, I'm going to close out with the video again for all those who was watching the video and it was interrupted, as Countess Jones said. So with that, let's come to our video and watch the closing aspects of it just a little bit so y'all get an understanding of the situation that y'all are subject to. Everybody listen. I'm gonna play it again.
There are a lot of great $600,000, $1 million, $2 million homes.
Your biggest decision is, do I want to go to the beach or the pool, and what am I going to grill for dinner? South Carolina, Hilton Head. What's going on there? People with families, everybody loves Hilton Head.
One of the best ways for an American family to create intergenerational wealth is to own some land. It's in high demand and they don't make it anymore. I'm standing on the beach of the beautiful island of Hilton Head, South Carolina, where after the Civil War, Black people owned most of it. But over the decades, the land was lost. And to this day, We got black folks that are still fighting to keep their little piece of the American dream. By 1910, African Americans owned around 16 million acres of land, much of it acquired through purchases and homesteading. But after years of violence, intimidation, and legal trickery, most of it was taken. Texas A&M law professor Thomas Mitchell has been tracking that loss for 2 decades.
Historically, talking about African Americans, despite this incredible acquisition of land after the Civil War, most of that property was not considered prime real estate. For example, Hilton Head, South Carolina. Until 1950, Hilton Head was remote. There wasn't a bridge from the South Carolina mainland out to Hilton Head Island, and the island was owned by majority African Americans. Right. What does South Carolina do? They build a bridge. Real estate developers realize, oh, there's a great economic opportunity, and they have visions of what has become Hilton Head.
The indigo, rice, and long staple cotton of the past have given way to the golf, tennis, and swimming of today's leisure society.
They started buying out individual families. There's hardly any black landowners left. And what's just happened as our society has advanced, areas that were once considered the backwaters no longer are the backwaters.
We're on a mission right now. Get this tangerine. The vulnerability of black land isn't limited to the coastline. It's widespread throughout the United States. Even in my hometown of Tallahassee, Sandra Thompson learned just how hard it can be to maintain possession of land that developers want to get their hands on. I remember growing up in Tallahassee. This was the stick. I went to school with people that lived out here. We'd be like, you live in the boonies, in the boondock.
It's actually now zoned urban fringe.
Urban fringe.
Urban fringe.
People try to buy it.
All the time.
Sandra's family were sharecroppers on this land. Her grandparents bought it in 1946 using money their son made serving in the military. But their will didn't clearly identify a single person who would inherit and manage the property.
When my grandmother passed away, it was left equally to her descendants. So that essentially created heirs property.
Heirs property. On the most basic level, what is it?
Heirs property is communal type property, where your ancestors would have purchased the land, and once they passed away, it transfers to the next generation and their descendants. It's fractional ownership, a property that could be owned by 200 people. Any one of those heirs could sell their percentage. That new owner can go to the court and say, well, we can't agree on how to manage this.
And force the rest of the folk to sell it, even if they don't want to?
Yeah. And so it was essential for us to move it out of heirs property status. And in that process, costs from probate to title clearing close to about $10,000.
Wait, so you own the land, but then you had to pay $10,000 to own the land again?
Exactly. Because of the cost. A lot of families don't clear title to their property. And so then it keeps them in a vulnerable economic risk position.
African Americans disproportionately own heirs property that everyone who was knowledgeable about this ownership form would tell them, run away. Do not ever own it under this structure. And so you're having the population sitting in this very vulnerable way, and oftentimes in a way that they don't understand how the law operates, sometimes until a lawsuit is filed.
Man, been in our family for at least 125 years. Daughter of my great grandfather. Land is for me, a lot of memories, part of my roots. I was father of the name Lewis, who worked at heirs. I guess say we lost.
The Lewis family owned 480 acres of land and a homestead in northern Louisiana. Because the land was heirs property, several distant family members were able to sell their share of it to a local timber developer named James Tucker. took a forced sale of the land that happened last year.
My great-great-grandfather raised 13 kids where that house sits. I mean, there are so many heirs tied into the Lewis properties. It'll make your head spin. Taxes were always paid on time. We were under the impression that could no one person from the family just up and sell any part of the property without anyone being notified.
Do you all know the relatives that sold their property?
I've only seen one once.
You in New York, wherever, going on with your life, you don't really know nothing about it. It's a little country spot right here. You don't know nothing about this here.
As part of the legal process, the forced sale of heirs' property has to be publicly announced.
I see
In
it's
the Lewis's situation,
cutting it
the
off
local
again. You
newspaper
see how that?
posted a notice in the weeks leading up to
String
the auction.
undeveloped.
This is a small town. Okay, this is not like
All
the
right.
Washington Post or
We're gonna stop that. So now you see that they're saying, based off what I'm saying, stream unavailable as a result of their saying I'm not complying with policy. No, I'm not complying with keeping a lie a lie. All right? But that's all right. You know what I'm saying? It's all right because now you see with your own eyes what's been happening. All right, let me make sure you see me. So in closing, this is the truth right here for y'all. Okay, this is the truth. No one can escape this truth, even if they try. I already showed you that I have a claim filed against me from the state of New Jersey as a corporation in regards to their presumption that I filed a self-generated deed in lieu of ownership of the land, contrast to all the deeds that were filed in the county by the county clerk on behalf of the state of New Jersey that are not proof of ownership as a result of their indefeasibleness. All right? So once again, it's a slow process, but it's a definite process that's surely coming to an end this year. Okay? I start trial. I go to court April 16th of 2024, which I'm moving for dismissal and moving for equitable remedies such as injunction, counsel profits, restitution, what's it called? Rectification. All right. These are the equitable remedies that I'm moving for under the common law of England, because under our authority and our capacity as an officer, I have the authority to do what I'm doing because it's authorized by the statute as filed with the county clerk office, because the county clerk has been taking and filing the property and giving it to people other than who it belongs to. So now I have returned for my property as established by the record. Now we know that under Article 4, Section 1, full faith and credit should be given upon acts, records, and judicial proceedings. And with that, we're here at the Third Temple English Church, England, on behalf of all the heirs, successors that were in this video. that was in the video. I love you very much. All right. So with that, we'll say, okay. So with that, we at the Third Timothy Church of England say peace to all my family. Love you very much. Talk to you soon. Share this message, subscribe, as well as donate your gifts if you can. Third Timothy Church of England or $ Clifford Jefferson L. Once again, I got a criminal case on behalf of all my heirs and successors. Your patronage is needed. You know what I'm saying? Because all those who are having this problem in regards to their estate, the only way you're gonna get it back is through me. All right, and that's my word. So with that, let's say peace.